We are taking a closer look at a ruling by 3 Tennessee appeals court judges that raises privacy concerns for some.
Now, charges were dismissed against David Eric Lambert, who was found guilty after taking close-up pictures of women at stores around Kingsport in 2016. Defense for Lambert claimed it wasn't a crime because he took the images in public, and the judges agreed. Caitlin Cluck spoke with attorneys on both sides of the case about what this means.
Current Tennessee law says that when someone willingly exposes themselves in public, like being at a store, they do not have an expectation of privacy. Under this statute, Tennessee appeals court judges dismissed David Lambert's 3 unlawful photography charges.
Essentially, it means if you're walking around in a public place and somebody's got a cell phone or a camera, they can take a picture of whatever they want, any part of your body.
Lambert was originally convicted in Sullivan County Court for taking close-up photos of women at 3 Kingsport stores without permission. According to court documents, one victim said Lambert grabbed her rear as she was trying to walk away. This led to a sexual battery charge that still stands, but attorneys with the Sullivan County Public Defender's Office successfully appealed the unlawful photography charges.
Our argument at the Court of Appeals was twofold. One was that the state did not have enough evidence to convict Mr. Lambert.
Assistant Public Defender Dustin Franklin said police went through Lambert's phone and never found any of the photographs, so no photo evidence was ever presented in court. Defense also argued Lambert's actions fell within Tennessee law.
The Court of Appeals simply affirmed the prevailing case law in every state in America that an individual does not have an expectation of privacy in what they present to the public willingly.
This statute was amended in 2018 to target photos taken in an offensive manner, such as photographing up someone's skirt. But William Harper with the Sullivan County District Attorney's Office is talking to legislators, pushing to define the law further.
So that it doesn't matter where you take it or how you take it, but if you take a photograph of someone's intimate part of their breast, their crotch, that sort of thing, that's what would trigger a violation of the law.
But Franklin does not believe legislative reaction to Lambert's specific case is appropriate.
The tightening of this law is a knee-jerk reaction to media and Facebook comments and things of that nature. This is a case where the justice system actually worked exactly how it was supposed to.
The DA's office is now trying to have the appeals decision reversed at the Tennessee Supreme Court. Meanwhile, sexual battery charges against Lambert stand. He'll return to Sullivan County Court for sentencing. He'll also be on the sex offender registry for the next 10 years. Caitlin Cluck, News Channel 11.